Okay, we're going to go through then the section by section look at the legislation, and then we'll have a period for Q&A to answer any questions you might have. Again, feel free to put those in the chat as they come up during the presentation. You have thoughts, you want to go ahead and log in there. Otherwise, you'll have to, if you want to raise your hand at the very end and speak your question, we'll have that opportunity as well. Next slide, please. So the first section of the compact, and again, the compact legislation is available on the Counseling Compact website for review, but going through at a high level here for each section. Section 1 is just the purpose statements, speaking to why the compact was created and what it aims to do. So those points that I made earlier stated here as well. Next slide, please. Section 2, definitions that are used during the legislation. So just important thing to point out here, licensed professional counselor, how we define it in the Counseling Compact is a counselor licensed by a member state, regardless of the title used by that state, to independently assess, diagnose, and treat behavioral health conditions. There are other definitions that are in there that may be of interest to you. Certainly won't read them all off here, but you can reference those as needed as well, and let us know if you have any questions about those. Next slide, please. Section 3 is particular to those requirements for states to join the compact. So we had mentioned some of these earlier in the presentation. So you see those listed again here. Next slide, please. So some additional ones not mentioned earlier, but things such as making sure that state is ready to participate in the compact celestial data system once that is created, their commitment to notifying the commission of adverse actions against a license, or if there's significant information of benefit to the other compact member states, to be able to share out that information, and then to provide for the attendance for a delegate at those commission meetings. Next slide, please. Section 4, regarding the privilege of practice. So these are the requirements for the licensee in order to be able to apply for that privilege of practice. So again, having to be holding a license in their home state as a member of the compact, not having any encumbrances against their license for the past 2 years, meeting those jurisprudence exams, and self-reporting any adverse actions or encumbrances or restrictions by non-member compact state within 30 days from the date of action. Next slide, please. Section 5 is particular to someone who may be wanting to obtain a new home state license and they're part of the compact and they're moving to a new compact state. So they will be required to get a new home state license, but provide for an opportunity for that that situation to be facilitated. So as far as certain information that the compact already has, it will help facilitate that new member state, that state which they're moving to, be able to process that more quickly, converting that home state that they're leaving, their license to a privilege of practice, so they'll already have that. So this just kind of explains that part a little bit further. Next slide, please. Again, here's some just wording specific to that. In this case, if a practitioner is moving to a non-compact member state, just stating that they'll have to apply for the single state license as normal. The provisions of the compact are, of course, just applying to those participating in the compact. Next slide, please. Here's a section particular to the benefits for active duty military personnel or their spouses. So during the course of service members' active duty, a military member or their spouse is able to designate a home state for the duration of that. And so if they're required to relocate to a different state, they're able to maintain their home state license without having to go through that, getting a new home state license during the duration of that. So whereas before, if you're not a military service member or spouse, you would have to go through that process, even though it may be facilitated and be able to happen a little bit more quickly than it would otherwise without the existence of the compact. This allows that service member or spouse just to maintain that without having to go through that process. Next slide, please. Section 7 is iterating the provision of telehealth services as part of this. So knowing that is an important part of LPCs and how they may deliver services, stating that this also, the provisions of this compact apply to telehealth services as well. Next slide, please. And then adverse action. So there are certain steps in case action is taken against a counselor's license. So if action is taken by the home states, then that will, of course, take action against, as dictated by the home state against that license, but also will apply to those who are participating in the compact, and that same counselor may have privilege to practice, so it would deactivate their privilege in all those states if that were to occur. States also have the ability, whether they're not the home state, but that counselor has a privilege to practice, they may take action specifically against that privilege to practice. Next slide, please. States may also join investigations of licensees, sharing important investigation information in order to coordinate on a response specific to violations that may have occurred across multiple states. Next slide, please.
All right, I will be taking over from Carl at this point. So I'm going to go ahead and walk everyone through the sections 9 through 15 of the compact, which pertain a little bit more to how the compact will be administered, the compact commission, and its responsibilities. Okay, so starting with section 9, the establishment of the compact commission. The section outlines the composition and powers of the compacts commission. So first of all, each state's board will select a delegate for the compact commission, and this delegate will have one vote on commission affairs. And so the compact commission is made up of one delegate from each member state. And the commission will be directed to establish terms of office for delegates and also term limits for them as well. And okay. And the commission will also have a budget, bylaws, rules, code of conduct, all those sorts of things that they'll need in order to carry out the work of the compact. And the commission will be led by an executive committee, which is composed of 7 commissioners who are elected, and then up to 4 non-voting representatives from professional counselor organizations. And additionally, I do want to note that meetings of the compact commission and meetings of all of its committees are all public, and the public will be provided notice of upcoming meetings, and the meetings themselves will remain public unless there is a specific issue that the legal counsel certifies that they can go into a closed session to discuss. But it's very limited number of issues, and it's very uncommon for them to go into closed session. Okay. All right, now I'm going to talk a little bit about the data system. So this is one of the most important parts of the compact because it's the way that states share all their information with each other. But the data system is set up, and so states will all share uniform data sets with each other, and they will be able to use this database to convey information about licensing, adverse actions, significant investigative information, etc. Between their boards and regarding counselors who are using the compact. Now, I also want to mention that adverse actions are included in this, but if they are expunged from the member states data, then they'll also be removed from the compact data system as well. And additionally, if there is information that a member state would like to designate that cannot be shared with the public and can only be shared with other member states, that is also permissible as well. And finally, this information is just shared in the data system between compact member states, and it is not shared with non-member states in any particular way. Okay. Let's see. Oh, and I also wanted to mention about the adverse action that when all the conditions are met and the counselor has finished resolving any of the issues related to the adverse action, and then that will also be removed from their record as well. Okay. All right, now we're going to move on to rulemaking. This is one where we get some questions who are from people who can be concerned that the compact commission may have too much control when it comes to rulemaking, but the scope of the scope where the compact is authorized to make rules is quite limited. They can only make rules relating to compact administration and business. And actually, if they make a rule which oversteps those boundaries, then the rule will be considered void. Compact rules also carry the force of law in all member states so that we can make sure all the compact member states are being governed in the same way. But if there is a case where there's a rule that many compact member states find concerning, a simple majority of the state legislatures can veto that rule. Again, this is very uncommon, but in the case that there is such a problem, we do have a provision to deal with it in the compact. Okay, additionally, changes to the rules also require public notice. In this case, it's 30 days. And if there's a hearing that is requested by at least 25 individuals or by a government agency, then the commission will also hold a hearing on the rule. And then again, one more time, just to reiterate, if the commission issues a rule which exceeds its authority, then the rule will be considered void. Okay. And also, I did want to emphasize that if these rules do not have to go through the state's own rulemaking process, they go through the commission's rulemaking process, and then after that, they are considered part of the commission's rules, and the member states of the compact have agreed to follow those rules. And so they do not have to go through the state's whole rulemaking process as well, because we're aware that could be quite burdensome to states. Okay. Next, I'm going to talk about oversight, dispute resolution, and enforcement. So this is the section that we like to say is kind of the teeth of the compact. It allows us to make sure states are really complying with the terms of the compact. And so it's very unlikely that there would be, a serious dispute between states, but we do have procedures to deal with that. So if there's a state which is not complying with the terms of the compact, first, another state might reach out, ask them, if they maybe mistakenly did not provide certain information, or if they intended to and there was a technical error. And so the compact commission will provide technical assistance. And if there are still issues after the technical assistance is occurring, there's a compliance committee, which will also help with the dispute resolution process. And then in the very unlikely event that there's no means of getting the state to comply, there is a provision that the state may be terminated from the compact. I believe this has actually never happened for an occupational licensure compact. And it has only happened for other compacts in the very rare instance that a state is not willing to pay its fees, which states may be required to pay fees to the compact commission, but those fees are not decided until after the commission has begun meeting. Okay. And yeah, so like I said, it's very unlikely that something so extreme would occur, but there are provisions for it in the compact just to make sure that states are all working to comply and working to share the information as best they can. Okay, so now I'm going to talk about the date of implementation, withdrawal, and amendment. The compact took effect on the date of enactment by the 10 states, so that would have been Nebraska for us this spring. And so since then, we began working on having the first initial meeting of the full compact commission. So states which join after this date are subject to the rules of the commission, as because the state has agreed to become a member of the compact, and so they will also have to follow all the rules of the compact as well. If the state does wish to withdraw from the compact, they can also do that. They have to enact a law which states that they're withdrawing, and then the withdrawal will take effect 6 months after the enactment of that law. And finally, member states can amend the compact if it turns out there is a big issue with something in the compact and member states feel the need to address it. There is a provision for them to do that. Again, this is also quite unlikely, and the drafting team, CSG, ACA, everyone else involved has worked very hard on this compact to make sure that there would not be any type of issues requiring states to all reenact. But if something does occur, there's a provision for that as well. Okay, now I'm going to talk about construction severability. So first of all, the compact is written so that because the compact is also state law, if there is an issue of conflict between the compact and a state's existing law, the compact will override that. And but if there's an issue with a compact law and the state's constitution, then the state's constitution will override that. And additionally, if there is found to be some issue between the US Constitution and the compact law, then the US Constitution will override, but that provision will be considered invalid, but the rest of the compact will remain valid. And all right, and then finally, one more time, just to reiterate, this final section just reiterates that licensees have to adhere to the laws and regulations, including the scope of practice where they are practicing, and the rules and bylaws of the commission are binding on all member states.